So can a bank report you as a charge-off month after month after month, or are they limited to only doing that one time? Let's find out in this case. My name is John Watts. I'm a consumer protection lawyer. I sue credit bureaus. I sue companies that provide or furnish information like JP Morgan Chase Bank in this particular case. And so what we'll do is we'll go through this opinion and see what the judge says about this. So this is, like I said, defendants JP Morgan Chase. They filed what's called a motion to dismiss, which says there's no way the plaintiff, the consumer, can win this case. The judge agrees and the case is dismissed, but the plaintiff is given a chance to amend or modify their lawsuit to try to meet the problems that the judge points out here. So let's see what happens. We've got Chapter 7 bankruptcy, and then the consumer pulls a 3-bureau credit report. I don't recommend that. If you want to know what Equifax says, go to Equifax. Experian, go to Experian. TransUnion, go directly to TransUnion. You do that through annualcreditreport.com. But in any event, the plaintiff says, hey, I discovered inaccurate, misleading, or incomplete information, and I've got 2 Chase accounts. One showed 24 consecutive months of charge-offs, and the other reported 25 months of charge-offs. So what is a charge-off? It's a term of art for credit providers understood as writing off a debt as a loss because payment's unlikely. And so the plaintiff, the consumer, says, well, continuously reporting a charge-off over many months is inaccurate because the creditor can only once charge off a receivable account rather than a continuous basis. I get this question all the time. Hey, my account was charged off in June of 2020. And here we are, I'm recording this in April of 23, and it's reporting all those months as a CO, so charge off, on my credit report. Is that right or wrong? For each month to report a charge off. That's what we'll see here. So the consumer sends a letter to Experian and says, hey, update my report to show it with completeness and accuracy. And then that letter was forwarded to Chase. So we've talked about this, I believe, in the last video. If you sort of picture over here, this is the credit bureau. You notify the credit bureau, and then they notified the furnisher over here. Now the furnisher has liability, responsibility under the Fair Credit Reporting Act. And then the furnisher has to report back to the credit bureau, who then reports back to you. Okay, so just sort of visualize that. And so the account was not corrected in the eyes of the consumer, so the consumer brought this lawsuit. So consumer says, hey, Chase violated the Fair Credit Reporting Act. Now this lists a number of statutes. Actually, only this 1681 S2B applies to Chase. You can't sue a furnisher under EB or under I. So they say, hey, look, you didn't conduct a reasonable investigation. So here's the plaintiff's view. Reporting charge-offs over many months was patently incorrect. The reason they're using that language is generally to be successful, you have to show there's an inaccuracy or an incompleteness. And that has to be either just, obviously wrong, or it has to be, maybe it's kind of right, but it's misleading. So let's look here. Plaintiff says continuously reporting a charge-off had a derogatory impact on the credit score, and this type of reporting, really harms you, and it makes lenders not want to lend to you. Okay, and they're going to talk some about algorithms and things of that nature. So Chase responds, reporting a charge-off over multiple months does not violate the FCRA, and that's neither patently incorrect nor misleading, and that this argument's been routinely rejected by courts. And you're basing it, plaintiff, on speculation and, supposed industry standards. All right, so what's the legal standard here? Well, a complaint must state a claim for relief that's plausible on its face. Well, what does that mean? Well, when you plead factual content allows the court to draw a reasonable inference that the defendant is liable. Now, this is not some probability thing, but it has to be more than just a mere possibility. Okay, so the court's not supposed to go, well, how would I rule at the end of trial? Or is it more likely than not that I would rule in favor of the defendant? No, that's not the test. The test is it plausible, which is more than merely possible, but it doesn't have to be, it's probable. And that, look, some of this gets into semantics, okay? But it's the idea that like it can't just be a 1 in a million shot. I mean, it's got to be a little bit better than that. So the court says, look, I'll accept as true all well-pleaded material facts, and I'll sort of construe them in favor of the consumer because the defendant, J.P. Morgan Chase, is moving to dismiss the case. So I'm going to, give every benefit of the doubt to the consumer. All right, to get that presumption of truth, allegations may not simply recite the elements of a cause of action. In other words, you can't just say, I found an error, I notified the credit bureau, they notified Chase, and Chase did a lousy investigation. You got to do a little bit more than that. So it has to be some underlying facts to give fair notice and enable the opposing party, that would be J.P. Morgan Chase, to defend itself. So draw reasonable inferences from factual allegations in favor of the plaintiff, but the court does not have to credit a plaintiff's legal conclusions that are couched as factual allegations. And then we give leave to amend unless it's impossible that it could ever be corrected. All right, so let's look and see what the FCRA. To ensure fair and accurate credit reporting, promote efficiency, and protect consumers' privacy. So there are duties on credit reporting agencies, that would be Equifax, Experian, TransUnion, Innovis, companies like that, and on furnishers. So a furnisher cannot report any information to a consumer reporting agency if the furnisher knows that the information is inaccurate. Now, when you notify a credit bureau, a consumer reporting agency, and then that company forwards your information to the furnisher, like J.P. Morgan Chase, now this section of the law, 1681 S2B, says the furnisher has to conduct a reasonable investigation, review all information provided by the CRAs, that's the credit bureaus, the consumer reporting agencies. Number 3, report the results to the bureaus. And number 4, report the results to all other bureaus when the furnisher knows information that they had been reporting is incomplete or inaccurate. And then modify, delete, permanently block reporting of the item when reporting to a credit bureau if it's inaccurate, incomplete, or unverifiable. All right, so that's the obligation on the furnisher. So you can bring a lawsuit against a furnisher who fails to conduct a reasonable investigation or continues to provide inaccurate information. So the Ninth Circuit says credit entry is incomplete or inaccurate when it's patently incorrect or it's misleading. So here's how to think about it. It's just flat out wrong, or it's flat out missing information. Alternatively, it could be, true, but yet it's misleading. Okay. And so we're not going to dive into all the details of that, but let's look and see what we've got here. So there's some regulations that Chase is required to charge off delinquent accounts after 180 days, or else their balance sheet would misleadingly reflect accounts as assets that have little chance of achieving their full value. Here's all that means. So I'm selling you a business. I've got accounts receivable of $1 million. So that's money that I'm owed. And I sell you the business for $10,000. That's a fantastic deal, right? Because I got no debt and you're getting $1 million asset for $10,000. Okay. Turns out all of my accounts receivable are owed by one guy from 50 years ago. Well, see, that would be misleading from an accounting standpoint to show that as an accounts receivable, because there's really not an expectation that I would get paid. Now, I may still be owed that debt. Maybe I can still sue. Maybe there's no statute of limitation in this example, but they can't report that as an asset. So I would have to charge that off. So that's all they're saying here. So credit bureaus can retain a charge-off notation for up to 7 years. All right, so here's the argument. Plaintiff does not dispute the two accounts were in fact charged off. And plaintiff appears to equate the initial charge-off event with the continued reporting. However, a consumer's debt does not simply disappear when a creditor charges off her debt. So a charged-off debt does not diminish the legal right of the original creditor to collect the full amount. It's very important because a lot of people misunderstand this. They say, oh, the debt was charged off so they can't sue me. No, they can still sue you. Okay. Where it gets a little confusing is if they send you a 1099 and say, hey, this debt is not collectible, then some courts will say, yes, they cannot collect that debt. Okay. But that's a totally different ballgame than what we're talking about here. Don't confuse those two things. A charge-off simply means that an accounting function has happened, but it does not affect the validity of the debt. Okay? So many district courts have rejected plaintiff's argument that reporting recurring charge-offs is incorrect or misleading, such that it violates the FCRA. And the Ninth Circuit says the reporting of multiple charge-offs does not support a plausible claim under the FCRA because plaintiff has failed to plead that anyone believed the account's been charged off more than once. And it was undisputed account can be charged off only once. All right. So here's the point. Your account is charged off. But every month that still is true. Now, it would not be true if you paid it, for example. But every month that it's a charge off, they can put in the little payment grid or chart or payment history, whatever it's called, that month is a charge off. And the next month is a charge off. And that's all that's being said here. So the plaintiff presses the court to follow the reasoning Wilson versus Equifax. And it says, in that case, allege inaccuracies in the form of multiple charge-offs, exclusion of positive data, inaccurate bankruptcy inclusion dates. Here, however, alleges the reported recurring charge-offs as the only inaccuracy, and that's been rejected. So here's an important lesson, that you should list all the inaccuracies in your dispute letter, for example, and in your lawsuit. So a lot of times people want to get really focused in on one thing. You know, it might be the status that's being reported. We'll see that in another video here in the coming days. It could be something else, but that's all. Now, that may be the only error that they can find. But if you can find more errors, you want to list those because maybe you lose on error number 1 and 3 and 5, but the court says error 2, 4, and 6, you're good. So don't limit yourself. Identify all the errors, all the missing information, everything that you can think of. And if you do bring a suit, then bring that suit with all those items listed. Okay, so here's the plaintiff says, well, it's distinguishable from like that Ninth Circuit case for a couple ways. One, lenders and employers only review the credit score as opposed to each line item. And that charge-off repeated month after month increases frequency and recency of derogatory, and in turn decreases the credit score. So this is the idea that when we look at the scoring algorithms, that's all anybody cares about. They're not going to dig into the details. We'll see this in another case about charge-off where it states it a little more clearly. But what the plaintiff is saying is, look, when you every month update me to show a charge-off, you're hurting my score, and that's going to affect my ability to get credit or to obtain employment. So the plaintiff says this is misleading because a consumer who has one reported charge-off would hypothetically have a higher credit score than a consumer whose score is calculated based on charge-off report on a repeated basis. So a credit reviewer is misled by this since they only look to the FICO score. And they say, hey, that wasn't made in that Ninth Circuit or in other cases, so you should still rule in my favor. So how does Chase respond to this? It's plaintiff's allegations about how credit scores are computed are speculative and conclusory. The court says, yeah, your allegations regarding a decrease in credit score are speculative, conclusory, do not give rise to a claim. And it says, hey, the plaintiff gives you a bunch of information on credit scores in general, yet fails to show the recurring charge-offs had any impact on her own credit score. So the point is, the plaintiff says, well, look, this would be very damaging to people in general, but never says this would be damaging to me, and here's how it would be damaging to me. Even assuming charge-offs did lower plaintiff's score, plaintiff still has not shown how the reporting is either patently incorrect or misleading. So here's an important point. And usually this is sort of goes against the consumer, but sometimes it goes against the credit bureau. So let me explain this. The Fair Credit Reporting Act, in a sense, does not care about your credit score. It cares about, is the information on your credit report accurate and complete? Now, if it's accurate and complete, whether that makes your score go up or go down is really not terribly important. Now, it may be important in terms of damages. Okay, if you're making a claim, my credit score went down, then yeah, you need to show it went down. But in terms of whether the credit reporting is accurate and complete, the credit score doesn't matter. And here's the part of the problem. There is no one mythical credit score. There are many credit scores. There's a credit score that's primarily used for car loans, and one for mortgages, and one for credit cards, and there's different versions of those. Some of those versions, for example, a paid off collection account has no impact on your score. Other versions of those same types of scores will penalize you if you have a paid off collection account, sometimes more than if you don't pay it off, at least temporarily. So we don't know what this will do to your credit score because we have to get more specific about which credit score. Now, normally this is the consumer saying, hey, my credit score has gone down, so therefore this must be false. And the credit bureaus go, hey, credit scores don't matter. Sometimes it works the opposite way, though. You have something that's inaccurate or incomplete on your report, and TransUnion, Experian, Equifax, Innovis will come in and say, Judge, it doesn't matter. If we took this off his report, his score would go down. So see, we did him a favor by keeping it on. Well, let's think about that for a second. What if I have my brother's American Express account that's been open for 30 years and, it's never been late, and that gets mixed up and put on my credit report, and it's not my account. I'm not an authorized user. It should not be on there. Well, I have the right to say, you know what, that's inaccurate because it's not my account. And I dispute it. And I prove to the credit bureaus and to American Express that is not my account. And they keep it on my report, and I sue them, and they go, hey, you can't sue us because we're actually helping you. We're doing you a favor by keeping this on your report. Well, imagine an identity thief who, I know it's sort of weird, but it actually happens. They steal your identity and they pay the bills on time. Does that mean you can't get that off your credit report? Because, that bogus account, fraudulent account is actually helping your credit score. No, we don't care about the credit score. We say if something is inaccurate or incomplete, we can dispute it and sue if they don't get rid of it. So anyway, I will sort of step off my soapbox here, but it's just something that's very annoying when the credit bureaus do that. And so we have to be careful not to fall into that trap. We focus on, is something inaccurate or incomplete? And then damages is a different question. All right, so let's go back to here. So plaintiff fails to show that misled any particular reader or could be expected to result in an adverse credit decision against her and would likely have difficulty. A couple court decisions here. It's unclear how any reader could be misled into believing multiple charge-offs occurred when it's undisputed a charge-off occurs only once. So further, credit score legal theory attempts to expand obligations. No affirmative duty on data furnishers like Chase to ensure generators of FICO, or it could be Vantage credit scores, when using otherwise accurately reported information, produce accurate credit score results. So keep in mind, Vantage is a different company. FICO is a different company. What they decide on your credit report that's helpful to you or harmful to you, that's all based on sort of their logic, their algorithms, their beliefs about what the accurate, complete data on your credit report shows. And as long as the data is accurate and complete, then what a scoring model does, like I said, doesn't matter on liability. Okay, but remember, that goes both ways. All right, plaintiff offers no authority suggests decrease in credit score based on accurately reported charge-off gives rise to a claim. So the plaintiff has 30 days to demonstrate that recurring charge-off misled any reader or could be expected to result in adverse credit decision. Probably be pretty hard to do that. I'm not sure what they did because this came out just on the 31st of March here. So what's the take-home lesson? Take-home lesson is we have to be very, very precise in our thinking. First, we say, is there an inaccuracy? Is there something that's just wrong, that is incomplete, that is misleading? And then the damages may be affected or may not be affected. It depends by what it did to our FICO score. But regardless of a FICO score, regardless of a credit score, we have the right, absolute right to have accurate, complete information on our credit report. And if a credit bureau won't fix that, if a credit bureau notifies a furnisher and the furnisher won't fix that, then they have liability and we can argue about damages, but they have liability by not having accurate, complete information on our credit reports. Okay, guys, thanks for watching this, and I will catch you in the next video. Have a good one. Bye-bye.